Okay, we are live.
Very good. Good evening, everyone, and thank you for joining the Enabling Ordinance Edit Ad Hoc. Again, we are reviewing the suggested edits that have been made to the Commission's Enabling Ordinance to determine their sufficiency and whether or not they are going to help the work we do or hinder the work we do, support the work we do, or otherwise impact the commission in some way. So thank you to everyone who has joined. We have members of the Coalition for Police Accountability, Kathy Leonard, Rashida Grenage. We have Mac Muir, the agency director for CIPRA. We have Tyler. What is your last name?
My last name is Rivera.
Tyler Rivera of the law firm of Garcia Hernandez, who represent the commission. We have our chair emeritus, Commissioner Regina Jackson, and myself, Marsha Carpenter Peterson, the chair of this ad hoc and chair of the police commission. So we are in our final review of many of the edits. And so we're going to start this meeting at 2.45.150. It's entitled Establishing Additional Committees.
Chair Peterson, Ms. Leonard has her hand raised.
Ah, so sorry. Yes, ma'am.
I just wanted to know for the record that we have two attendees.
In the chat? Or
Yeah,
the
two participants on the call, Sister Asada and Risa Jaffe.
Very good.
Thank you both for attending.
So much. I do not see either one of them as
you have to slide over to the participants. You see panelist under participants.
Yeah,
there's
I do.
Two categories. One is panelist, and then on the right it's attendees.
Okay, well, welcome attendees. And of course, this is Monday, June 8th, and it's 6:44 p.m. So 2.45.150 is entitled Establishing Additional Committees. And the edit that has been made by the council is chair may establish either an ad hoc or standing committee by majority vote of the commission. Membership on a committee shall be proposed by the chair and ratified by a majority vote of the commission. The commission must obtain city council approval prior to the creation of any standing committee only if the committee will require additional resources. A proposal to create a standing committee of the commission must include information regarding the cost associated with staffing and standing committee, if any, and the costs of complying with noticing and reporting requirements resulting from its establishment. City council approval shall not be required for creating temporary or ad hoc committees. Are there any comments before I say anything?
Yes, I'm trying to remember why, and Rashida, you may have the answer to this. Why did the original ordinance state that only the city council could appoint standing committees?
They don't appoint, they approve.
I'm sorry, approve. But I think that the commission had to get permission from them first before they could create a standing committee. And I can't remember the reason why. Does anyone remember?
Yeah, the reason is that I think a standing committee may require additional staff and additional resources that may not be in the commission's budget or in the administration's budget. So I think that that's the reason.
Well, for instance, if we wanted to make our racial profiling a standing committee, and we wanted to hire a facilitator for a forum that, and Chair Emeritus can step in here, for the public to comment. If we have it within our budget, I think this is saying it's not requiring any additional resources.
Correct. That is but it says only if the committee will require additional resources.
Correct. And
Yeah, and with the standing committee, we would need, posting on a regular basis, the same process that you have to go to post regular commission meetings. And that would require other city staffers.
Okay, thank you for,
but is that really additional resources
Yes,
that are not within what they do, unless you're saying like, okay, we are going to have
People
a
have-
special meeting and
people have, well, that's what
K-pop.
standing committees are, just that. They have a regular schedule, just like our commission meeting does. And so, yes, that would be additional resource from KTOP and from, I guess our staff who will be posting the agenda. But if we needed the city liaison, which the position we used to have, that person supported the standing committees. And that's in part why we don't do standing committees anymore, because there are so many limitations, and the pandemic kind of messed all that up. We couldn't meet in person, and so ad hoc seemed to be a bit more efficient in terms of process.
Right. Well, again, additional resources outside of our budget. Is that what this is speaking to?
Well, it would be, I mean, I don't know, does KTOP come out of our budget, or is they just?
I have no idea how. I assumed that was what KTOP existed for. I didn't know that every time we need them to do something,
We have to check
yeah,
their
well, we have
availability
to
and,
check,
yeah.
because
Mhm.
if we have the resources, I'm not sure. Mac handles our contracting, so Mac, your hand is up.
Yeah, KTOP wouldn't come directly out of the commission's budget. There's no bill that comes in, but this speaks to sort of city resources where you'd probably be asked to give what's the estimated amount of time for KTOP, for the city clerk's office that does do the final posting of the agenda. And so it's not billed. It would be considered a separate additional resource, however minor.
Well, if this doesn't help us in any way, chair may establish that and vote membership on it shall be proposed. So this is, again, the process they are trying to manage, how we establish these standing committees. And we don't have to go to the city council if it won't require additional resources. So can someone posit an example of creating a standing committee and no additional resources are required? Because what it sounds like is that anytime we create a standing committee, it will require additional resources. So this is a further, I would say, clamp on our ability. Or they discovered that we have done this and it costs them money. Either an ad hoc or standing committee, by majority vote of the commission, membership on the committee shall be appointed by the chair. Well, yeah, we know that that's how it would come into fruition. only if the committee will require additional resources.
Yeah, I'm okay with it. I just couldn't remember the history.
Well, I'm not sure I am, because they really kind of, they're giving us, I don't know, sometimes they just give us a sleeve off their vest, because this only clarifies that we can't do this if it is going to require additional resources. And what I'm hearing is that these standing committees always require additional resources.
I don't think they're saying you can't do it. It just means that you have to have council approval to do it.
Well, that's where we've always been then. I don't know why this edit, I guess.
Because before, I believe that you had to go to, and correct me if I'm wrong, my recollection is for a standing committee, you always had to go to city council for approval. But what this particular section is now saying, or this draft is saying, you only need to get approval from city council if you need additional resources. Am I reading this correctly?
I think you are, Kathy, and I think what you're saying is correct.
And
So
okay.
do we want, do we want it to remain the way it was, or do we want to say,
Well, I
look,
think
we only come to you if we need more money?
the city is protecting its budget. I guess there were costs associated, and they wanted to make sure we understand that we can do this. But if it costs the city more money, you're going to have to come to the city council.
So Chair,
And
you
I
said
would-
that the city made this change?
Yeah.
Okay.
Yep.
All right.
And I guess it's benign in the sense that it's really only saying the same thing. Well, no, I will say that it's saying that the chair can establish the committee, and we don't have to go to the council, only if it doesn't require any additional resources. And if it does, then we do. So that's the state of affairs.
Right. And so what is everybody's feeling on that? I think now we all understand that, but how do we want to move forward with this? Is this okay for everyone?
Well, I think they control the purse strings. If it require, when they say additional resources, they're talking about additional city resources. I'm wondering
No,
why.
I understand that.
Why
But I
can't
think
we use
actually
our
this may
own
be a
money?
benefit to the commission.
I hope
It may
so.
be a benefit to the commission if the commission wants to start a standing committee and they don't need any money, then they don't have to go to the city council. Whereas before, right now, you do have to go to them regardless of whether you want more money or not.
Yeah, and I don't want to belabor this. I guess all I'm saying is that our resources cannot be used. If it impacts city employees in some way, be it K-Top or the city clerk's office or whatever, the various pieces that make a meeting occur. So, okay, let's go. This will take us a long time. The chair, let's see, public statements. The commission chair may authorize one or more of its members to issue statements to the public regarding the commission's official business to the extent such business is not confidential or privileged under state law, etc., etc. Only after the statement has been approved by an affirmative vote of not less than 4 votes in a public meeting. Commissioners may publicly discuss their roles as commissioners and commission's public and official business for the purpose of educating the community, provided they adhere to the notice requirements of the Brown Act and Oakland Sunshine Ordinance. Any comment?
I guess I'm wondering about that last sentence. It seems onerous. If a commissioner goes to a community meeting to discuss the role of the commission, um,
What does the
I don't
Brown Act and the official sunshine ordinance have to do with it?
exactly. I don't know. I think you need a legal opinion on this one, but it seems unusually limiting, and I don't understand it really.
I would put a period after educating the community and delete the rest. And we can ask for a legal opinion if we want, but that would be my suggestion.
Okay.
I think this may be an answer to what the past chair was doing. She was making statements to the public, and the full commission had no idea what was going on. So it was kind of like, I don't want to say a dictatorship, but it kind of was.
No, this is for the part where she authorized another member of the commission to make those statements. So this is about authorizing, deploying someone else. Have we already gone over what? Can you move up again?
So does the chair, before making a public statement, does the chair, I guess I'm talking out loud here, so it may be a little scattered. So sometimes you have to make a public statement as things occur in the public arena. And you may not have time to talk to the full council or to the full commission about a statement that's going to be issued. So right now, Chair, if you're going to make a public statement, do you run it by the full commission first?
A written public statement, yes, but if you notice, I'm not the one who will allow any, I don't take news interviews for that reason, because how I might feel on an issue may not reflect the views of the commission. So any statement that has been released since I've been chair have been run through the full commission approval.
I think we need to make a distinction between the first part of this and the second part. The first part is official statements. The second part has to do with publicly discussing roles. So these are two fundamentally different kinds of communication.
That's my trouble with it too, because suppose in the second sentence that a commissioner happens to be at a public meeting and someone says, hey, we've got a police commissioner here. Can they just interject for a moment and we can get a statement from them about what the police commission does, what their role is? So I see these as two different things as well. And that's where my confusion
Well,
sort of
actually, there's a
arose.
third thing that's missing completely. And under public statements of the commission is that the chair speaks for the commission. And while the chair may authorize one or more members to issue statements, the chair speaks for the commission. And the chair and the commission chair may authorize one or more of his to issue statements, and that's what happened previously. That's
So maybe you need a first sentence then to clarify the roles that the chair would normally issue statements.
Yeah.
But she does, or the chair does have the authority to authorize more people. But then we need to, I think that second sentence is troubling.
Yes, so let's attack that one. Commissioners may publicly discuss their roles as commissioner official business for the purpose of educating the community. And I mean, we're trying to develop an event calendar so commissioners can go out to the public and can educate the public about what the commission does. But beyond that, they should not be speaking about policy or comments on things like that. I think that would be inappropriate, especially if it's not something that the commission has taken on, or the commission may be in the process of. Maybe in the process of working on. So
Mac's hand is raised.
Chair, may I suggest some language here that I think aligns with what you're stating? That'd be commissioners may publicly discuss their individual roles as commissioners for the purpose of educating the community, but may not speak on behalf of the whole commission without
Yeah.
prior authorization.
Great.
Say that again, Mac, please. Commissioners may publicly what? Mac?
Speak publicly.
Oh, sorry.
Go ahead, Matt.
Muted there. Commissioners may publicly discuss their roles as individual commissioners for the purpose of educating the community. Comma, but may not speak on behalf of the commission without authorization from the chair, the commission chair. This may not be exactly the right language, but I think it captures what you were saying, Chair.
Yes, thank you. For the purpose.
Okay.
So we are getting.
Can we enlarge the ordinance, please?
Is that better?
Maybe one more step up. Thank you, Ms. Micah.
Sure. Is that better? That's a
Much better.
200. Okay.
Oh, that's fantastic. Thank you.
You're welcome.
Okay. So the chair speaks for the commission should be added. Commissioners may publicly discuss their roles as individuals for the purpose of educating the community, but may not speak on behalf of the commission without authorization from the commission chair. Okay, great.
I like that. Thanks, Mac.
Thank you.
Electing a commission
So,
chair.
One last comment. So should we make this 2 paragraphs?
I think you're right. Let's go back up. So really, Micah, just put this, the chair speaks for the commission. Put that as the very first sentence.
Right.
And then this is the next one. That's correct. The commission chair may authorize one or more. And then the next one should be commissioners may publicly discuss.
I would combine.
Yeah,
The chair speaks for the commission. Yeah, I would combine those first 2.
mhm. I wanted it just to
Commission
be
chair. Yeah, I would make, yes.
Yeah.
And then the other should stand alone.
But what about this? This is redundant. Commissioners may publicly discuss their roles as individual commissioners for the purpose of educating the community, but may not speak on behalf of the commission without authorization from the commission chair. Yeah, so this last part down here, you can delete. Yeah. Okay, guys, let's keep going. Election of chair and vice chair. Okay. The commission shall elect a commission chair and vice chair at its first regular meeting. Each calendar year and as necessary to fill a vacancy. Which is what we'll be doing on Thursday. Hello. Okay. Staff assistance and administrative support. The city council shall allocate a full-time administrative. Oops.
May I make a suggestion? Since
Sure.
we're recording this, can you also include the section number as well as the title of that section?
Of
And
course.
I think it'll be easier for the public to follow
Of course.
when they listen to the recordings. Thank you.
So now we're on 2.45.180 entitled Staff Assistance and Administrative Support. A, the city council shall allocate a full-time administrative position to the city budget for the purpose of providing adequate administrative support for the commission. This full-time administrative position shall also serve as a liaison to the city administrator. B, the city shall ensure that the commission is equipped with adequate resources to fully function as a public agency, including but not limited to a credit card for use for official purposes, immediate access to technical assistance and support, and administrative support as needed to effectuate the commission's charter role and duties to conduct proper and effective civilian police oversight. And they had eliminated a lot of other language. Can you go down? Can you go up again?
Yeah, Chair, I have a issue with this administration, the administrative position being a liaison, because later in this section, the city is supposed to provide a liaison. So it's a little confusing. I think we need to clarify.
We want a liaison within the city so that when our administrative person needs has a question and needs to access someone in the city administrator's office, we want to have one person that is assigned to us. So this full-time administrative position shall also serve as a liaison to the city administrator. I think it's trying to set up that relationship, but this person doesn't serve at the pleasure of or have any duties related to the city administrator's office. Just that we want to have that person in the commission, and we want this person over here in the city administrator's office. So I know we have put something in, if you go down a little bit, Micah, about the city, there. Shall allocate a full-time administrator to the city budget for the purpose of providing adequate administrative support for the commission. This full-time administrative position shall also serve as a liaison. The city shall ensure that the commission is equipped with adequate resources to fully function as a public agency, including but not limited to the credit card and immediate. Okay. Well, that's what we were trying to set up, Ms. Grenage, this relationship that each office knew who their counterpart was if there was a question. So our administrative full-time person and a liaison, which I think we finally worked it out, was Felicia Verdin, right?
Yes, Chair, and that's the relationship. So whenever she has a question, she reaches out to me and we work through it and vice versa.
But if you look down on the next page,
Next.
there's a whole, there are 2 new paragraphs that don't have letters. And I don't know whether that's because they're part of the previous paragraph. Maybe somebody could clarify that. It's very, very
What page are you looking at?
They look identical.
exactly my point.
It's
It's
like
very-
someone was trying to make a decision as to whether to put them at the top of this section or at the bottom of the section.
And that's altogether possible. And so it might be
Not exactly the same.
redundant. Okay.
This, because in B, it says the city shall ensure that, and then on the next page, it says the city council shall allocate a full-time administrative position, and then the city shall ensure that the commission, it's all very jumbled and confusing and redundant. I don't know what happened here, but it has to be cleaned up.
Yeah.
They look like they read identical to me. A and B are just set forth at the end of that section as well, and we need to strike one or the other.
I believe this was just a copy paste error. It was copied and pasted twice and moving things around. So the second set can honestly just be deleted. They are the same thing.
That's what I'm thinking, yes.
All of this, Tyler?
Yeah, that can go. It's just a repeat.
Yeah, it does read the same, doesn't it? Now, before you go, does that answer your question, Ms. Grenage? Kathy, your hand is up.
Oh, that was from talking just a minute ago. I've just lowered it. Thank you.
I think
Yeah.
that,
Yes, that's fine.
okay, very good. Let's move on. Training. Woo, immediately upon appointment. Oh, sorry. 2.45.190, Commissioner Training. A, immediately upon appointment, each commissioner and alternate shall familiarize themselves with City Charter Section 604 and with chapters 2.45, 2.46, and 2.47 of the Oakland Municipal Code. The Office of the City Attorney shall provide training to the Commission in public meetings or via video recording as appropriate. We need to stop there because we're trying to address our training as not being the requirement of the City Attorney's Office, but a combination of the City Attorney's Office and our law firm, Garcia Hernandez. So how do we do that? Because they are not just the only ones providing training. So the Office of the City Attorney and Commission Legal Counsel shall provide training to the Commission in public meetings or via recording as appropriate. Does that settle that?
No, I don't think that it should be just limited to those 2 entities. We've talked in the past about community organizations providing trainings. So I would open the door to, and perhaps other community organizations or whatever, having a role in training.
Okay, so the Office of the City Attorney, you put a comma. Yeah, Office of the City Attorney, Commission, comma, Commission Legal Counsel, and other community organizations as appropriate shall provide training to the commission in public meetings or via video recording, etc. I don't think as appropriate. Or is that too vague to put in an ordinance? Okay. B, within the commission's budget, there shall be a line item for attendance at conferences offered by organizations such as the National Association for Civilian Oversight of Law Enforcement, also known as NACO. Fine. What happened to C? You need to renumber this. C, D is
Okay, but
now,
it's not limited to NACO though, right?
no,
It just says such as. Okay, very good. Thank you.
and then the D is now the C. Each commissioner and alternate shall complete the city's online training on workplace retaliation training at least once each calendar year. Commissioner and alternate shall complete the first such training within 60 days of appointment or as soon thereafter as possible. The Public Ethics Commission shall request and receive an annual report in January of each year regarding the commission's workplace retaliation training activity for the preceding calendar year. Mac, you have your hand up.
Yeah, just regarding section B,
Yeah.
I would suggest conferences offered by organizations including but not limited to, instead of such as,
Oh, okay.
and that'll guarantee there's funding for that and certainly leave open the possibility for additional conferences.
Thank you for that suggestion.
Thank you.
Including but not limited to, comma. Okay. Micah, please make a note that I would like to discuss paragraph C with you offline. Just
Okay.
a post-it note somewhere in your life, on your desk, on your computer.
Okay.
Okay, D, within 6 months of appointment or as soon thereafter as possible, each commissioner and alternate shall receive training on, and we have a list. 1, basic principles of constitutional due process and administrative hearing procedures. 2, I can't see 2.
Sorry, I'm still writing my note.
Okay.
Sorry, there we go.
Sorry.
I need more hands.
No, that's okay.
Okay, there you go.
2, the legal requirements for maintaining the confidentiality of personnel records and other confidential documents or information. 3, the negotiated settlement agreement in the case of Delphine Allen et al. Versus City of Oakland and all related court orders for so long as they remain in effect. 4, constitutional civil rights guaranteed to all citizens as such rights are affected by law enforcement. 5, the California's, no, take out the California's Political Reform Act, Cal Code, Government Code Section 81000 et sec, Oakland's Conflict of Interest Code, Oakland Municipal Code Chapter 3.6, California's Brown Act, California Government Code Section 54950 et sec, close paren, Oakland Sunshine Ordinance, and Oakland's Public Records Act. And they have all of their code sections. Okay, 6, California's Myers-Millis Brown Act, MMBA, yeah, that's what's acronym. The Public Employment Relation Board's administration of the MMBA, the city's memorandum of understanding with the Oakland Police Officers Association and other represented city employees, the City Civil Service Board, and other relevant city personnel policies and procedures, which training shall be provided by the city administrator or their designees from human resources and or employee relations, and shall occur in open session. Micah, make a post-it note about number 6.
Okay.
7, California's Public Safety Officers Procedural Bill of Rights Act. Somehow the code section, though, was deleted. Yeah, and it shouldn't. I wonder why they took that out. Relevant department, number 8, relevant department and CIPRA policies and procedures.
So a couple of us have our hands raised.
I'm so sorry, Kathy, please go.
So with respect to item 3 under this, under E, where we mentioned the negotiated settlement case, can we also provide the citation for that case so that it's easy for people to find it if they, need to, without having to hunt for the citation?
Okay.
Thank you.
Mac?
Yeah, Micah, once you're ready, if you could scroll down, I want to refer to what I believe is now section 7.
Okay, give me 1 sec, please. Okay, scroll down where?
Sorry, section 6.
Okay.
Yeah,
here?
so there'd be training on the city's memoranda of understanding with the Oakland Police Officers Association, Civil Service Board, and other relevant city personnel policies and procedures. May I just pose to this ad hoc whether it is, or understand whether it is necessary for all such trainings to occur in open session, specifically as it relates to the city's MOU with the Oakland Police Officers Association. I just seek understanding regarding the necessity of that being an open session.
When we have things in open session, it's an ability for the public to also hear what the rules of the road are also. So for many, I would think they probably have never been exposed to the California Public Safety Officers Procedural Bill of Rights Act and what it entails, what it prevents, etc.
Absolutely. My thinking would be that in training new commissioners, perhaps in a training provided by legal counsel, one might be able to get a different perspective on some of those challenges that speaks uniquely to your role as a police commissioner, and and understanding that the public education aspect of it is important. I guess my hope would be that there would be, to the greatest extent possible, really a blunt assessment of the challenges, which I'm not certain always happens in open session, candidly speaking. Maybe I'm wrong there, but I guess I see some benefit in having an attorney-client privileged conversation regarding it's specifically the MOU. But I am posing that to the commission or to the ad hoc because I see both sides of it.
I'm not sure I understand what your concern is, Matt. It's the MOU is a public document and it's passed by the city council. It's, I don't understand what would be gained or why you think that there is a benefit. If you could explain that.
My thinking is that to the that essentially council is privy to the privileged information, to personnel information that has intersected with the commission's work previously, and may be most effectively able to weave that into training in a non-public setting, in a private setting, because there would be essentially be confidential information that would need to be discussed in order to give practical examples of how this impacts the commission's work.
But they can also give practical examples in hypotheticals. It doesn't have to be related to a particular case. If there's an issue with a particular case, I would think that it would only come up in a discipline committee, for instance, which is confidential. And therefore you do get that nuanced, maybe legal opinion or application of the law if necessary. I don't think the public really understands what this does to, oversight, this police officers' procedural bill of rights, the limits on what can and can be done vis-a-vis officer accountability. So I'd like to keep it like this, but that's my opinion, and this is an ad hoc. So anybody else have?
Ms. Leonard's hand is up.
Okay. Oh, Miss Leonard often doesn't lower her hand.
That's exactly what happened. Thank you, Chair, and I apologize.
So is there any other sense of, I like this as an open, I think this is going to be illuminating for the public to hear the limitations that this Bill of Rights Act puts on oversight. So, and any discrete question a commissioner might have can be, accessed one-on-one with counsel. So, I don't know, Matt.
And I certainly appreciate that, and I wanted to pose it to the ad hoc, and if that makes sense to me too.
Okay. So we can move on from this. Any other questions though about that particular section? And let me make sure I look at the chat.
I have one quick note from Micah. For number, I think it's now number 5, where it references the Public Records Act. Yeah. So at the very last line for the citation for the Public Records Act, they've updated that. It needs to be 7920. And I guess the city didn't update that in this draft, so we should update that here.
This right here?
Yeah, that's now
Okay.
7920.
Thank you.
Okay.
All right. So are we going to get to page 26? Let's keep
Yes.
going.
All right. Okay.
Are we here? F. No, H. What is this F? Is the number incorrect?
No, H7. Yeah, Tyler, I'm not sure how this is going.
Well, because they originally had it in alphabet format, so I don't know if this was a copy paste error from their document or if they actually just wrote it that way. But the F was probably from the way it was originally written. We can get rid of that F. I don't think if they want to go to numbers, we don't need it.
Well, here we got 7, 8. And so what is this? 9 with an ABC. There should be, oof. Instead of F, it should be a 9. See, because up above it's 8. And then
Yeah, I think the best, if we want to go to numbers with 9, the best line would be on the one below it, because that's the next training that's listed. The difference between this section and the one above is just the timeline that it has to be done. But I don't think we need a letter there at all. We can just start with in addition, and then move to 9, 10, yada yada yada.
Well, once we clean it, we'll see a little bit clearer. And I think you've made the print small again.
Did I? Okay.
So no, that's okay.
One sec. I'm trying to do that. So we want 9, and this is going to be 10. And every 10. Tyler, I'm just going to say and so on. You'll know. For the renumbering, yes. Renumber.
Yeah.
All right.
So we can move on.
Yeah. That makes sense to you, Tyler?
Yep, I got it.
Okay, perfect. All right. So the font, the size is small again. Give me a sec. Let me go to 200. Oops, you know what, that one, that's really small. That better?
No, it's the same.
It's the same. This is what it was. It was at 200. Let me see if I can go more than, let's see, 200 and.
No, you know what? I had opened up another panel.
Oh,
I think this was fine.
okay. Okay. All right.
Okay, come on, we're at 20.
Mhm.
Got a half hour left.
Is this where you are here? Did you look at all of these after the renumber?
Yeah.
Okay.
And then there's that. What is that? Is that part of the renumber?
The G.
No, the 6.
6.
It's part of the renumber group.
Yeah.
Okay.
Mm-hmm.
Okay. Now G. We got rid of F, so you got to figure out where this G is coming from, and it's the H. Is this the new F? Yeah. The city administrator shall assist the commission in scheduling and facilitating all training and orientation required by this section and by Charter Section 604. Within the commission's budget, there shall be a line item for attendance at conferences. Oh, wait a minute. We've already said that.
Mm-hmm.
But we didn't say it that way. We didn't say it should be or did we say it was a budget line item? This is a repeat.
This is actually, oddly enough, this is actually currently in the code in this spot. We can delete it if you want. But it's already there.
It's already up.
Yeah, because I just pulled up the code too because I thought that looked weird, but that's actually there in this spot.
in this spot.
Yeah, yeah. So if this stays here, this is exactly how the code is written right now. But if you guys want to remove it, since I think it's addressed elsewhere, we can.
How different is this than the way we've already stated it, if at all different?
We'll have to go back and look and see. I don't know off the top of my head what it says earlier, but I know that Naples come up. But we can also leave it.
In the
Here it
commission
is right
budget,
here.
there shall be a line item for attendance at conferences, including but not limited to. Okay, yeah, delete that other one. It's redundant. Although we didn't say the city administrator shall assist the commission in scheduling and facilitating all training and orientation required by this section and by charter section 604. So leave that and get rid of the rest of it. No, I meant get rid of that and leave the rest of it. Okay.
Yeah, that's right, right? Yeah.
Yes, you're absolutely right. I said it wrong, but you got it right.
Yeah.
You knew where I was going. Thank you. It's been a long day. G, ongoing or repeated failure to complete training within timeframes prescribed by the city charter and or this section may constitute a substantial neglect of a commissioner's duty. I think that's appropriate to have that in there. So the next section, 2.45.200, hearings. It shall be the, oops.
May I just have a quick question? So, what is the remedy for someone who fails to complete the training within the time frames prescribed? We're saying that it constitutes a substantial neglect of a commissioner's duty, but what is the recourse?
There should be recourse, I guess, with the Ethics Commission.
Okay, a referral to the Ethics Commission.
And result in a referral to the Ethics Commission. And may result. Accountability. Okay. Two 2.45.200 hearings. It shall be the sole and exclusive responsibility of the commission to determine the order and conduct of any public hearing consistent with applicable law. I don't think we have a problem with that. 2.45.210, Authority of Public Ethics Commission. This is interesting. Why do we have that in our enabling ordinance, Ms. Grenage?
Because there has to be an enforcement mechanism for your authority. If you don't get the files and records that you request, then there has to be a consequence.
And it's through the Public Ethics Commission. Okay.
Yeah.
And I just a side note here. Graham, Bond Graham and Ali filed the lawsuit against the city of Oakland for just this. The police department refused, and the city of Oakland refused to turn over documents and redact them. And they received $199,000 last week in attorney's fees. So this is critical. And maybe if this happens to the commission may have a recourse in suing. Add that to your budget. I mean, I don't know where the money would go. If it would just go to the general fund, I think it should come to you, but there is a precedence for suing and getting fees. Especially if you have outside counsel.
So this
You
is
know, the outside counsel, you wouldn't be paying their fees. Oh, the city would. It's just a transfer of funds, I guess.
so this is our enforcement authority. Okay. Guess I know I knew that. I'm just tired. 2.45.220 administrative hearing upon removal of chief, and this is all new language.
Yeah, and I have to ask legal counsel why it's here. It has nothing to do with the commission at all that I can see. So I'm not sure why it's in the ordinance for the police commission.
My guess is that they wanted this in the code. It's a lot easier to amend the code versus the charter, and this to them felt the best way to do that. Since it doesn't involve the commissioners really, but it falls kind of in a similar trend to police commission, police department. It looks like down here the commission can play a role in this administrative hearing. They probably wanted somewhere to put it, and this to them made the most sense.
So is the charter silent as to this? Because the charter supersedes the ordinance.
Well, the charter allowed the chief to have a review, or was that, yeah, it must have been under the charter because he's not covered by the MOU, and he went to that independent arbitrator and
No,
had
he
a review.
has his in his contract. This is
Ah.
all in his contract. So because he's not part of the union, so
Right.
it's not. So this is in his contract. I still don't see why it is in here at all.
To answer your question, Miss Leonard, I can definitely double check to make sure, but what I do know off the top of my head, the charter is mostly silent on an administrative hearing. It talks about how the commission or the mayor can remove the chief, but it doesn't say anything about an administrative hearing. So this wouldn't be superseding the charter or trying to conflict with it. This is just new material.
Okay, so given that, then where is the law for the administrative hearing upon removal of chief? Does that language or something addressing this situation occur somewhere else in the code?
No, it's in his contract.
Oh, if it's in his, okay, so it's in his contract, and it may not be in a subsequent chief's contract. I'm just trying to play the devil's advocate here. So say it's not in our present chief's contract, then how would the administrative hearing, what would happen?
Well, this is
I mean,
here.
there's got to be some kind of
Yeah.
procedure. There's some kind of procedure set forth somewhere with
Right
respect to an
here,
administrative
right
hearing.
here.
I know, but Rashida is saying that Rashida is saying it has no place here. So I'm saying, where does it have a place? And is it already covered somewhere else?
Well,
It should be in the municipal code somewhere.
Right. We need to make sure that it doesn't conflict with the municipal code then.
yeah, well, here it says the administrative appeal procedure shall be as follows, colon. So scroll down.
Right, but if it's set somewhere else in the code, we need to make sure that we're not conflicting with the code.
It shouldn't be here at all because this has to do with after the chief has already been terminated. He's been given a notice of termination. This is his appeal. This is his right to appeal.
Which has nothing to do with the police commission.
Exactly. That's my
Then,
point.
yeah, then it shouldn't be here. Then I agree.
Chair, may I add a point of information?
Oh, yes, you can.
So as I read this, it appears to refer to what's called a Luby hearing, which is from the case Luby versus City and County
Yeah,
of San Francisco.
That's the name clearing. hearing.
And so is this proposing creating essentially an additional distinct appeal for the chief?
Well, again, whatever appeal rights this is purporting to set up, it's not an appeal before the commission.
Understood. I guess what I'm reading this as is an entirely separate new appeals process, distinct from a Luby hearing, or that it just is a Luby hearing and that doesn't need to be in there, the name clearing hearing.
Even if it were a Luby hearing though, Mac, it's not heard by us. And even though
Yes,
we might be the ones who terminated him, because we do have that authority to terminate for cause, we don't want to give the appearance that there's some sort of hearing that appears before us.
correct. And so I would agree that I don't see this as being relevant to the commission. With that said,
And since we're on the subject, just for purposes of this recording, can you explain what the Luby hearing is in a digestible, short way? Thank you.
Okay, when you are terminated and you have the right to a hearing, that is usually the full, I guess, panoply of rights that you have. A Luby hearing is only offered under certain circumstances for certain, I think, positions, and it might be if you weren't
For
terminated
for
for
exempt employees.
yeah, if you weren't terminated for cause, but you were exempt, yes, you get to clear your name, especially if you are like a financial officer and you're accused of embezzlement or something. You want a Luby hearing to say, no, I didn't do that as a chief financial officer. I did not engage in any of that. So I think this is for at-will positions when you have a Luby hearing. It's been a minute, guys. I'm so sorry. I can't remember. I haven't done any of this for 10 years. So let's talk about LUBY.
Chair, you're correct. It's for at-will, part-time, or contract employment.
Okay, I knew it was limited to a certain class of people. And
Okay,
it
well,
would be to the chief, but again, the implication here is that somehow it's within the commission's purview to hear this hearing. We don't want to certainly give that impression. So I think we would want to yellow this out as not being appropriate.
who
All this
did the
blue,
city attorney bring this put this section in, or did we
all
do
this
that?
blue stuff was by either the city attorney or the city council.
It was the
Okay.
city attorney.
Okay, well, should we strike it right now or talk to the city attorney?
Well, we've highlighted it, so at least whomever
They'll
is
know.
this up, they will
Okay.
know.
All righty.
Okay, and this is CIPRA. We've pretty much been through this with MAC. So definitions, we have a whole definition section for chapter 2.46 Community Police Review Agency. Definitions at 2.46.010. Let's scroll down to see what we, okay. We've defined misconduct. Officer shall mean a sworn individual employed by the department. Subject officer shall mean the officer who is the subject of a complaint. I think we're okay with all of this. I'm hearing nothing. I'll keep going. 2.46.020 creation. They just capitalized some things. They took out this paragraph, this sentence, the commission in consultation with the agency director shall determine the number of existing agency staff who would work at such location. What is this about? This is about your street level. Why is it in here? Okay, yeah. So you're here taking in public complaints regarding alleged misconduct, which is capitalized now. Thus, some of the agency staff should be located in a street level or ground floor visible office that is accessible by public transportation. The commission, in consultation with the agency director, shall determine the number of existing agency staff who would work at such a location, and that is eliminated. And then it goes on to say hours of, it sets the hours of the office. Mac, I don't think the commission needs to tell you who works in a street level office, so.
Yeah,
that was eliminated.
I suspect that was flagged as a potential union issue, but it makes sense to me. Just ensuring that there is staff is, I think, priority number one.
Right. So then we go to B, C, D. It just capitalized some of the words. E, videotape record, that just said video record. F, no change. G, no change. H, at least twice a calendar year and as permitted by applicable law, submit a report to the Public Safety Committee, which shall include the following information. Mac, that's all set out here. Any questions, changes? Most of this is just capitalizing certain things. Are you good with this?
Looks good to me.
I
Number-
want to ask a question based on comments that Ms. Asada made, which is there a reason we can't include the racial demographic information about these these complaints?
So we can definitely aggregate the racial demographic, and is it in there
I don't
at
think
present?
so.
I'm happy to include that. It's just the demographic breakdown of complainants or victims. I guess we'd want to, I think victims is in many cases more instructive.
And in previous CPRB reports, they also indicated the district, the kind of origin by district of the complainants.
I believe that's in there, and this may be in another section where there's a different report. But if Micah, can you scroll up to the top and just make sure?
Let me know.
Oh, no, sorry, further down.
Oh, down. Okay.
Yeah, we just want to see 1 through 10
I see.
altogether.
It's
Yeah,
too
so it has the
hard to
demographic
solve.
profiles of the complainants to the extent that information exists or is voluntarily provided. And then the council district is number 1. Yeah.
Okay, my bad. Thank you.
Mac, when you get a chance, I put a definition in the chat for Luby hearing. Take a look and see whether that's the right one, please.
I'm going to defer to the chair and commission council on.
Chair and commission council.
I read that, but again, when we speak of Luby hearings in municipal employment or government employment, it is just that. It is a name clearing hearing. And it's right. Usually to clear their name in cases where they have been subjected to public accusations or stigmatizing charges. Like I said, I used the example of the chief financial officer being accused of embezzlement.
Okay.
highly stigmatizing. Okay. Agency director. I think we're good there. Initial investigator, city charter. There are no changes here. Okay, here's paragraph G.
Can I go back for a second?
Absolutely.
Back to the report. Based on the conversations recently about the 250 days, I think it would be informative to include the number of cases that were not closed by the 250-day deadline.
Where is that, Ms. Grenache?
I'm going back to the report. So it would be number 11.
Ooh.
Am
It
I in
would,
the right section?
Yeah, you want to scroll down.
Those are
then
10, and we're
there's
gonna
10.
add 11?
So scroll up, scroll up.
and where you
And-
see
right.
10, she wants to talk
To
about.
add 11.
And so just be another line that says the number of cases closed in,
The number of cases that were not completed within 250 days of their being filed.
just if clarity could be sought, is that within date of receipt from by CPRA? Is this, because as you're aware, there's sometimes at least a day gap from internal affairs? Or is it the day it's filed, period?
I think the day it's filed, period.
Great.
Ms. Grenache, does that look okay?
Yeah.
Okay.
Okay, we're almost on page 26 and it's 7:59. Can we go over just a little? Okay,
I'm good with that.
okay, we're on G. This has to do with your budget, Mac. Go back up, Mike. Okay. Preparing a proposed budget for the agency. The proposed budget shall be delivered to the commission by February 1st of each year in accordance with the city administrator's proposed budget timeline or such other date as set by the mayor. In addition to submitting the agency's proposed budget to the commission, the agency director may submit the proposed budget directly to the mayor and the city administrator by the earlier of April 1 of each year or such other date as set by the mayor. Consistent with the agency director's authority to organize and reorganize the agency and their designation as a department head under Charter Section 604E6, the commission may not direct or require the transfer, deletion, or other alteration of funds and staff positions that the city council ultimately budgets to the agency. Well, okay.
There's a grammatical error. I should
Timeline.
After we get April 1st of each year, etc., then it says the agency director's authority to organize and reorganize the agency and their designation. It should be
It's.
his or hers.
Or its, no, and its designation as a department.
No, it's the director's authority to organize and reorganize the agency and his or her designation as
Oh,
a
I see.
department head.
Oh, I see. Yes.
Ms. Grenage, I do believe that language is intended for a gender
Oh,
neutral
that's
they, them.
right.
I was just about to say that. I was like, yeah,
Yes,
they're
I
probably
got
supposed
checked.
to be there.
Yeah, I got checked on that by the city attorneys.
Yeah.
Okay,
All of us
grammar,
OGs don't understand these new pronoun uses.
okay, fair enough.
Oh, I hate it. I mean, I don't hate what it does, but it just confuses the English language. Any other duties consistent with the agency's powers and duties, etc. I think we're finished with this. Background and checks. Agency staff, that's the only thing changed in 2.46.050 background checks. B, the only thing that's changed here is some wording, staff positions, etc. 2.46.060 mediation program. Substantively, what's changed here is some language added. The chief and agency director shall agree upon 1, types of cases that can be referred to mediation. 2, guidelines regarding the process, including but not limited to confidentiality and agreement of the parties to participate. Seems fair enough. I think after mediation, semicolon should be an and, or somehow this. It doesn't matter. It's just a small grammatical question. Okay, 2.46.070, Authority of Public Ethics Commission. Again, if the agency does not receive the files, etc., then the enforcement shall be through the Public Ethics Commission. And I don't think we have any disagreement there.
That's the end of page 26. I apologize, Chair. There was one note that I think is a little critical on the mediation section.
Sure.
It says any commissioner, last sentence, or second to last sentence, any commissioner, city employee, or former, and then it's just lined out
That's
here.
enough. Yeah.
I don't know what the intention is here, but there needs to be a question.
Okay. Well, I think you should yellow that, because I think it should say, or former department sworn officer shall be appointed mediator. We want to keep that language.
And perhaps the intention was just to knock out department, so it's a former sworn officer, so that it's not limited to OPD, but I don't know.
That's a good question. Would we ever want a sworn officer from another jurisdiction, just Emeryville, pick one, to serve as a mediator?
No,
Okay.
Agreed.
No way.
So then cross out department. I think it's current or former. Why is this? I wonder why they just said, because any commissioner.
You want to put
Oh,
current?
former or current sworn officer shall not be appointed mediator.
Yeah, current or former. I think that would be the same with any of these others, wouldn't they?
actually, I think it should be even broader than that. I think it should say any city employee, because it used to be that the administrative hearing officer did the mediations back in the day. They had, you know, a hearing officer that also heard complaints about parking tickets and all kinds of other, you know, bars closing past midnight or whatever. I mean, he heard all kinds of cases, including these kinds of cases. So I think it should exclude any city personnel, all city personnel.
Okay. Then do we want any current or former commissioner? Any current or former city employee? I don't think we want that, do we? Because what if a great mediation firm was set up, and maybe it's by a city attorney, former city attorney. So any current or former commissioner or any current or former city employee or any current or former sworn officer shall be appointed mediator. Is that the world we're trying to create?
Yeah, somebody who is entirely outside of the system of Oakland government.
Okay, then Micah, go back to the beginning of the sentence and say any current or former commissioner, any current or former city employee, shall not be appointed mediator.
And you want another one for the department sworn officer, or you want to take that out?
No,
You want to keep that, right?
that
Okay.
current or former sworn officer. Well, then we should say, and we mean from any jurisdiction. So we want it to, we don't want department to be there. Just,
Department's out. Okay.
yeah,
Shall not. Okay.
yeah.
And just, I know we're over time, but a last stand defense of former city employees. I mean, there are some folks who worked for the city 20 years ago for a year and may have, I'd see benefit in leaving that window open as long as they're not a current city employee.
I have to disagree because I think sometimes former city employees still have relatives that are within the city and they still have connections to people who are still in the city government. And they may even be within the police department. I just think it's cleaner if we just leave the city out of it altogether. Even people who've retired 15 or 20 years ago often have relatives or associates that are still in the city.
Or sometimes people leave the city and come back.
I hear that.
But what I'm hearing is that in this world of mediation, we don't want anybody who's been connected to the commission, to the city of Oakland as an employee, or any former sworn officer from any jurisdiction.
Yep.
And any current or former sworn officer. Is that clear enough? Department or other jurisdiction?
Looks clear to me.
Okay, I don't want any ambiguity about what we meant by sworn officer. Okay, keep going. Keep going, and I think we have reached where we want it to be.
Yes.
Okay, so it is 8:11. I consider this our second run through this.
But what about the other document?
Oh, the other page. So do you want to spend at least the next 20 minutes on that other page? Can you stay?
I don't think we need another 20 minutes. I think 5 minutes probably will do it.
Okay, let's turn to the other page.
You can give
Yeah,
me
let's try
just a
5 because I don't have another 20 either.
Okay.
Sorry.
if you can give me just a second so I can properly save this document to open the other one.
Well, please properly say.
Yes. Enablement come on, council, Tina. All right, as of today is 7/8/2024. Draft. Okay, save.
So I think we need to look at 2.45140C. Does the committee wish for the agency to be included in Skelly hearings as a participant? I think we need to address that, and I'd like to hear from Matt.
Okay, the
Can you give
document is
us
up.
that number again, please?
2.45140C.
Is that in this list? So go down, Micah. I don't see.
Right here.
2.45.140C. Does the committee wish for the agency to be included in Skelly hearings as a participant? Now, the Skelly hearing occurs after any discipline committee and any IAD meeting on discipline. Is that right, Matt?
Skelly, yes. Well, it can occur both before and after. So
I
if
think
there's an initial disagreement, there would be a Skelly hearing after that, and then there could be again another discipline committee. There could possibly be two discipline committees because the chief and the CPRA director have to agree at two junctures, one before at the end of the investigation and another after the Skelly hearing.
I don't think we've had a discipline committee after a Skelly hearing.
No. Although that may be the Skelly backlog may have something to do with that, but essentially there needs to be a re-agreement if there is a recommendation from the Skelly officer that there would be a change in discipline.
You
And
would be there not as a participant. Would you be there as a participant or as an observer in a Skelly hearing?
Is the officer represented by counsel in a Skelly hearing?
My understanding is they may be, yes.
Well, in that
Oh,
case, I
yes.
think
Yes, and remember that was, what was it? Lieutenant Doran?
Durham.
Yeah, yeah, he was saying part of the delay is the officer wanting a certain attorney.
right.
That attorney wasn't available. And there's
Right.
there is no requirement you have a specific attorney, just that you have representation.
So in that event, I think Matt or somebody from CIPRA certainly, maybe CIPRA, one of the CIPRA attorneys should also be present.
I mean, we certainly reserve the right to be present. It's a serious expansion for us of our hours to be required to be present at every single one. And I mean, what I would love is that the city must notify CPRA and provide opportunity for CPRA to be present at all these
Okay, well,
Skelly
then
hearings.
that should go in the ordinance then.
So what would you like, Matt?
I'm not sure which I'm looking at
Well,
145.140.
yeah, in 2.45.140C.
Yeah, so send a notice of intent consistent with city department shall offer the subject officer a Skelly hearing to be conducted by a Skelly officer. Skelly officer. I think it's just a representative from the agency. May be present at any such hearing, sorry.
Yeah, but it could be legal, or it could be the agency director, or someone that the agency director sends
Yeah, or I guess it's the agency director or their designee may be present at any such hearing.
The question was whether or not they had legal representation, and therefore should there be a legal representative there?
So generally speaking, the city attorney's office is going to represent the city in these, in a Skelly hearing.
Okay.
But even speaking to what I mean, and I guess a Skelly hearing is really a check on due process. It's giving the opportunity, in this case, the officer, the opportunity to respond to the allegations, and have there be assessment that the officer received due process throughout the investigation and these related parts. So I can't say I can speak with authority on the extent to which, like, we need to be represented at as a party in each of these instances, because this is really about the officer responding to the discipline.
But I think the city attorney, the problem we've had, especially losing arbitrations, is that the city attorney doesn't know the case, doesn't know the evidence. They come in at the last minute and they don't really know anything.
So I can't speak to that dynamic so well in the Skelly process. The CPRA staff is called as witnesses in Skelly hearings. So to the extent that there might be an investigator who investigated this case that's being heard, they're liable to be called as a witness by either the city or the officer. So and even then, the city attorney can certainly ask us for information about the case. I just worry that the issue that you're highlighting is one that's more about arbitration than it is about Skelly, where when these arbitrations are held years later, there is apparently an information gap that builds.
But how could they force your attorney to take the stand and be a witness?
Well, I guess I
I don't
wouldn't.
think they can do that.
Yeah, I wouldn't
The
see.
attorney is representing CIPRA. They
Yeah,
can't.
They're not a
They're not a
fact
party,
witness.
so they can't call the attorney to testify.
Yeah, they're not a fact witness
yeah.
unless they were a fact witness.
Exactly. This really comes down to the particulars of an individual case. Ensuring we're present allows us to gain, or not even may be present, must be offered the opportunity to be present at any such hearing. Would be stronger language so that these hearings don't just go by without us being aware.
And then are the Skelly hearings recorded? Or is there a court reporter there? Because there should be some way maybe that CIPRA can get a copy of the proceedings. I don't know if that's something that you would be interested in or that you need, but
I don't think Skelly
can you
hearings
address
are
that, Matt?
recorded. Unless that's a new rule.
Not that I'm aware of, but I would say that at the conclusion of a Skelly hearing, the chief and I receive a report as to what the determinations were and why, or if there was any recommended deviation from what we had initially recommended. So yeah, I don't know that this is the moment. We'd love to have there be a requirement that we are offered the opportunity to be present at any such hearing. But
I think that would be fine. I think that would be fine, but the notation here is 2.45. It shouldn't it be 2.46?
Well, this is the discipline section. For whatever reason, it falls strictly under the commission.
But
because
the commission has nothing to do with this.
Yeah, because this is related, it's tethered to sort of post-discipline committee hearings.
Well, the
So
Skelly hearing is always going to come after any disciplinary meeting or disciplinary committee.
Yeah, it should be in 2.46, and it should be under agency director.
I'm happy to do that.
Okay, so slap it in there, Micah. Move the agency director or their designee may be present at any such hearing should be in 2.46.
And I might suggest the agency or the city must afford the agency director or their designee the opportunity to be present at any such hearing.
Right. Yeah.
The city, one more time, Mac. I was trying
Must afford
The city or the city attorney.
The
just
city.
just the city does the trick because it might be the department too. Must afford the agency director or their designee the opportunity to be present at any such hearing.
Or
There's
designee.
no such, you have to say any Skelly hearing.
Oh, at any such Skelly hearing.
Yeah.
Oh, because there's such because we're out in a new section, right? Any
Exactly.
Skelly hearing. So you
Yeah.
can
Wait.
knock out the such, Micah.
The city must afford the agency director or their designee the opportunity to be present.
At any Skelly hearing.
Great.
Okay. And you're going to move that to 2.46. Okay.
You got that, Tyler? I'm just taking notes for Tyler.
Yeah, I do. Thank you.
You're welcome.
Okay, there's a typo here from the city. Does the commission want to propose a deadline of 20 days or 30 days prior to the closing of a hearing in the process of terminating the chief? We're taking all of that out anyway.
We are? Why?
This is all about the hearing for the chief, isn't it?
Yeah. That was the Luby hearing
Oh, yeah.
conversation.
Okay, 2.46.040D9. Does the committee wish for the agency's director's report to include the number of non-sworn department employees who have refused to comply with a written request for information and the number of non-sworn department employees who have refused to comply with a valid subpoena?
I would say so.
Okay, so that would be a number 12, 11, number 12?
Yeah.
Yeah. Okay,
We want this.
yeah. It was rephrased, but yes. Okay, now what is this? Oops.
Sorry. One second.
Oh, okay.
Boom, boom. Okay, here we go.
Okay, 2.46.070. Does the committee wish for the Public Ethics Commission to have the authority to investigate allegations that a city department head failed to comply with the charter requirements of providing the agency with requested records within 10 days of the agency request not being fulfilled rather than 15?
Yes.
Okay, and where this would be yes. Okay.
And would this always fall to the department head? That's just, I see it's to investigate the city department head. The requests are not always going to be directed to a department head. So I just want to make sure that's clear. We're saying that the
Yes.
department head is responsible.
So we'll take out the city department. No, I'm sorry, take out head.
Take out what?
HEAD after department.
Okay.
I mean, I'm fine if it falls to the department head. I just want to make that
Well,
clear.
it may fall there, and it may even be that you direct it there. But what is this within 10 days of the agency request not being fulfilled rather than 15?
I believe there's the charter states that documents must be provided within 10 days, but the Public Ethics Commission does not trigger until 15 days. Am I correct there?
You might well be.
Yeah, that's what this comment was getting at.
Okay. So how do we write this, Trevor and Mac, so that this last part makes sense?
Well, it's consistent with the charter, just say 10 days. The charter should certainly supersede the Ethics Commission's own procedures.
Yeah, it's a copy paste of the existing section, and it just says 10 instead of 15.
So
Yeah.
you want,
So then it should take out the not being fulfilled rather than 15?
is that what you're saying?
I don't know, Trevor.
Yeah.
Mac.
So Mike and I can make the edits in the section. Instead of it says within 15 business days, we can just change that to 10, and the rest of the section can be left alone.
Okay, so you know that this rather than 15, request not be fulfilled in 10 days. Within
Right.
10 days. Yeah, that's what it should, not rather than 15. I see. So the Ethics Commission has 15 and the charter says 10. No,
Like that,
it's,
Tyler?
Say that again.
Like that, fulfilled in 10 business days or days?
I'll know how to make the edit on the document. I got it.
okay. All right. 2.47.030H. Does the committee wish to include reversals of discipline as added monitoring subject for the OIG? Yeah, I would. Because it leaves, once it leaves us, we don't know what the ultimate decision has been made until maybe a year or 2 years. And so it would be nice for the OIG to let us know what discipline has been reversed. We never hear, we don't really get a report on how many of the cases OCA loses.
You get that from the city attorney's report.
Did we get it as how many they lost or how many were reversed?
How many the city lost on appeal in arbitration?
Okay, we do have that. Okay. I can't remember, but yes, I know we were trying to augment that list of what they report to us. So as long as that's in there. But the answer is yes to this 2.47.030. Okay, 2.47.040A. This modification.
Sorry about that.
That's okay. This modification could introduce a potential conflict with the charter. The commission has the duty to oversee the OIG, allowing the IG to have the sole discretion in deciding whether and how to conduct any OIG audit, evaluation, inspection, or review, including decisions regarding timing, methodology, findings, recommendations, and reporting, could conflict with the charter's grant of authority to the commission to oversee and/or supervise the IG. Does the ad hoc wish to address this issue, and if so, how?
I personally think that the evaluation that you do of the IG would be the means by which you oversee the work. I mean, it should be part of the evaluation protocol that the commission does. and that would be agreed to by the IG as an element of your evaluation.
I don't
Of
think
who-
that, I don't think that's the way we should approach this at all, though, Miss Rashida.
Okay,
I think that if we are providing in an enabling ordinance, in this enabling ordinance, the discretion to the IG, we can't therefore evaluate that discretion that has been granted to her by the enabling ordinance and address it in her matrix or his matrix, evaluation matrix. This is talking about something bigger. I'm going to wait and talk about this one maybe with the full commission or within an ad hoc. I think we have an ad hoc on IG. Because I think this was part of some of the stress that built up between the commission leadership and the IG's office. What does it mean to oversee the OIG? And I'm not sure that we want to grant sole discretion, because if we grant sole discretion, then we do lose any oversight of what.
Right, but then you don't want to micromanage her either, the
office
IG, because,
either.
yeah,
No,
because they are the professionals, you know.
oh, no question about that. And I don't think that it's either one or the other, sole discretion or no oversight. There's something in the middle. Mac,
I would just note that CPRA, the commission can vote for us to investigate certain matters, and just with each of these provisions, trying to envision a worst case scenario, there could be a circumstance in which the CPRA director reaches out to the commission and says, here is a matter of great concern. And the commission could unanimously believe this is a matter that needs to be handled by the IG's office, but then is subject to the IG's office solely, to their sole discretion. And I think that that's where you don't really ideally want to run into that issue.
I really, I would highlight the word soul, Micah.
Where, oh, right up there. Okay.
Yeah.
I think there can be a happy medium here. I do agree with deleting the word soul, but on the other hand, how to conduct an audit, I mean, that's the job of the person that you're hiring to know how to do that.
Well, that's
I
why
mean,
she had whoever has the discretion in deciding, but I don't believe it's the sole discretion. That's the word.
And the language is, the IG will have sole discretion in deciding whether and how to conduct any OIG audit, where I think the concern is less about how and more about whether.
Yeah, I would agree with that. I think how is really the problem, because it's a group of civilian commissioners who are not trained auditors telling an auditor how to do their job.
Oh, no question. No
So
question.
that's wrong.
I don't have a problem with that. I just said I'm not sure soul should be there, and I agree that, or how to conduct, because we are not auditors.
Right. So I think if you take those two words out, it will be okay.
Okay. I think you're right.
So no need to delay for you to speak with the commission. You want to add it as above.
We did it in the ad hoc.
Now we didn't start at the very top. There are two you guys didn't address before we jumped into this one. So do you want to do these last two?
Sure. We're all over. I don't know if this is a Brown violation. We're going too long, but we're trying to get work done. 2.45.030F, the Brown Act specifically excludes members of of a legislative body like the commissioners from the meaning of employee for purposes of personnel matters that may be discussed in closed session. We can still request that the selection panel refrain from discussing references in open session to the extent possible, but does the commission wish to do so or delete this revision instead?
I think the language that we arrived at, which was to encourage them to refrain from discussing, etc., is fine language.
Okay, so asked and answered. We've addressed this.
Yeah, this has been addressed.
Yes. Okay. So the last one, 2.45.040C. Does the commission wish to keep this revision of the OMC or to remove it to the commission's rules of order? Okay. Tyler, what is 2.45.040C?
This is related to placing items on an agenda. I think we touched on this one. I don't remember what the answer was, but it's the revision now is the commission's rules of order shall provide a clear process for the commission by a motion and a vote to schedule items to or remove items from future commission agendas in accordance with applicable law. Subject to the Brown Act, the chair and the vice chair shall retain the ability to set agendas outside of commission votes. Motions and votes to schedule or remove open session items shall occur in open session, and motions and votes to schedule or remove closed session items shall occur in closed session.
That's reasonable. That sounds like what it should be.
So yes. Add.
We want to keep
Keep.
we want to keep the revision of the OMC.
Thank you.
Right? Right, Tyler? You have it up, right?
Yeah.
Okay. All right. Ad hoc. We have made our comments. We have gone back through our comments, made further revisions, and cleaned this document up. It now is Micah and Tyler clean, so we can send it to the full commission, hopefully by our next meeting, vote on it, and send it to Council Member Cal.
When can we get a copy of the cleaned draft?
Clean. You should get it. Well, certainly when we post it for the second meeting, it'll be the meeting in July 25th.
We can't get it before then?
If we have it. Tyler, Micah, how soon could we get the cleaner version?
I can talk with Micah tomorrow and figure out a plan forward. I imagine end of this week, beginning of next week would be ideal, what I was thinking, but I can talk with Micah about how soon we can get it or how we want to go about it.
If
Thank you. I appreciate
I'm
that.
involved, let me just say, if I'm involved, it will not be this week because we have an off-site meeting that I have to focus on. So I need to be hands-on for that. So it would be next week sometime.
Okay, well, we meet on Mondays.
So it would, it's gonna be, maybe we'd have Friday to kind of look at it unless you're gonna look at it, Tyler.
Yeah, I think I can.
Okay, Miss Leonard, we will make every effort to provide it to the ad hoc before we post it for the July 25th meeting.
Thank you. Yeah, I'd like to take a look at it before our next meeting,
Okie doke.
you know, and have enough time to look at it carefully.
If it is not ready by next Monday, though, we don't have a reason to meet.
Well, that's true too.
Okie doke. So we will keep you informed.
Thank you.
I didn't
You
think,
are always welcome.
yeah, I didn't think we needed to meet again if this is, I mean, if we're done with our reviews and our comments and our edits, and they're all going to be incorporated, and then it's going to the commission, I'm not sure why we need to continue to meet.
Okay, so there will not be a meeting, but we will try to give you an advanced copy before posting in case you catch any other little things that need to be cleaned up before we post it. How does that sound?
Great.
Okie doke. All right, listen, it is 8:43. We've gone over by 43 minutes, but that's just a testament to how devoted and committed we are to getting this work done. So I want to thank everybody for being here and hanging in with this work. And I wish you a good rest of your evening.
Thank you. The same to you.
Thank you, Chair.
Thanks so
Everyone have a
much.
great rest of the week.
Bye,
Yeah.
everyone.
Everyone.